Here in the court, I was in the hearing there till 1 o'clock. They said they're breaking for an hour. They've another issue to deal with. So really what was discussed so far in the court was the proportionality of the order, which really isn't addressing whether the order had validity in the first place or not. It's kind of discussing the detail around the order. Really the matter today is whether or not the order was valid or not, whether it's lawful order or not. The proportionality of the order, if the order has been deemed unlawful and how it has been arrived at is deemed unlawful, is really irrelevant. Now, it might not be irrelevant in terms of future orders, but that's not really a topic for discussion today. Because, and I'll tell you why, it might be an interest of those who form the laws, but I want to tell you this. Really the question today is whether the convictions should have been quashed or not. Now, of course, they're going to address, in judicial review, they're going to address the issues, again, that were addressed in the court because they're reviewing the judge's decision. So they have to look at the reasoning of the judge. If they fail to look at the reasoning of the judge, they fail to do a judicial review. If they just talk about the ins and outs of this detail and that detail and measure, the size of this and the size of that, whether that's they're not actually doing a judicial review. The judicial review has to establish the mens rea of the judge, his thinking on the matter, and his thinking has to reflect the extant law. If his thinking it doesn't reflect the law, then he's not doing his job properly, and that has to be called into question. So if you're just going to talk about the size of the order and not whether the order should have come into play or not, it's like you're sort of dancing around the point. It's like you're dancing around the issue. So they may very well look at whether the order was arrived at properly at a later stage, but so far they haven't. Now, if you're going to say, well, was the order proportionate? Proportionate to what? What are you trying to establish? You see, what you're trying to achieve has to be discussed if you're going to discuss proportionality. Why would a judge's goal ever be to remove the rights of a person when it's his priority to ensure that the rights of the person are upheld? You see, that's the only way that courts can operate properly. The function of the court is to ensure that everybody's rights are upheld. It's when an action of an individual comes against the rights of another, or the bodily safety or anything of the other, that the judge has any reason to remove that person from society or their full spectrum of rights. So if a person hasn't actually exhibited that they've broken the law, a judge removing their rights, or even in any measure reducing them, is the judge breaking the law and failing to carry out his office. Do you understand? A judge, those guys in there today shouldn't be discussing whether, they should have completely removed me from the bull ring or just told me I can't use the amp. That really shouldn't be the issue of the day. The issue of the day should be whether the judge was right in placing any sanction whatsoever on me. That's really what should be put in place. Once they establish that, then you can discuss proportionality. It has to be decided whether the judge was right in trying to place a sanction. Was the court on that day right in saying whether that person has behaved antisocially or not? And then they have to ask the question, has the man behaved criminally? Because if he hasn't behaved criminally, how can we say he's behaved antisocially? Is there now a different requirement on members of society to be deemed as behaving in a socially acceptable manner that differs from behaving in a lawful manner? So does now what you're expected to do in society differ from lawful conduct? So, because if it does, your rights are already diminished. You're already off on the wrong footing. And it's not looking promising for the court, because they've already gotten straight into discussing the proportionality of the order and not looking at the first port of call. Was the order justified or not? That's not looking good. Because that's doing things upside down. If I was a judge and I was thinking reasonably, and I was thinking, in a logical sequence, I would say, lads, let's first save ourselves some time here. We have to establish whether the order was lawfully given or not. How do we do that? We have to look at the evidence that was given on the day. We have to see whether there was irrefutable, substantiated evidence against this man saying that he has behaved in an antisocial manner. Can we see any of that? No. There's no solid irrefutable evidence, only the attempt to remove the ability to record any solid irrefutable evidence. Because the only solid irrefutable evidence available today are the videos on my YouTube channel. So it's a bit suspect when the powers that be are trying to remove your ability to accumulate solid irrefutable evidence instead of using that solid irrefutable evidence in the court. Don't you think that's suspect? That's a hiding tactic. Hide, hide, hide. The question in the court was, why would you be asking somebody not to record when otherwise in society people are freely entitled to record? Well, there's your answer. One might try to prevent somebody recording if they didn't want the material that's being recorded to be readily available publicly. So the fact that they went straight to removing the ability to record is suspect behaviour that cannot be ignored. And if it is ignored, then the court are willfully ignoring the most blatant question. Why was this man asked or ordered to stop recording? Not whether he was asked to stop recording or not was disproportionate. Why was he asked to stop recording? Not whether they should have varied the order in this way or that by removing, the amplifier, or maybe you can only preach between the hours of 12 and 1. Now you're talking about reducing the rights of the people when the High Courts, the Court of Appeal, the Criminal Courts of Justice priority is to ensure that your rights are in no way reduced. They're supposed to be upholding the law, therefore your rights, not discussing different ways in which they can reduce them. Or whether, it would have been a better idea, hypothetically and historically thinking, whether they should have removed this man's right to speak in the entirety of Wexford. So dance around the point, go to the outer extremities of what's implied, and don't deal with the core issue. Seems to be, so far, the purpose, directive and drive of the day. When are they going to deal with whether the judge has found reason to remove a person's rights? And how can a judge remove a freedom of somebody that he cannot enforce the removal of, even if that person goes to prison? It's absolutely unheard of that somebody would be told to stop talking. Stop talking! Why, am I breaking the law when I'm talking? No. So, are you breaking the law telling me to stop talking? Yes. If somebody's telling you to stop speaking, they're breaking the law. Unless it's your mother at the dinner table. If they're telling you, if they're trying to remove your rights, if they're trying to tell you that you should that your rights should be reduced, and not giving you the reason as to why, then they're not doing their job. There has to be a lawful reason to ever remove or reduce the rights or freedoms of a person. Liberties should only be reduced when the law has been broken. If the law cannot be shown to have been broken, your liberties should never be reduced. So why are the court dancing around the issue today? Why are they talking the detail and not whether the ban should have been put in place or not? Why are they not actually looking at the mens rea of the judge? Why are they not looking at his thinking? Why are they not looking at why he would arrive at such a ruling in the first place? Why are they not looking at that? Beyond other people rathering you not do it, which is rather irrelevant, why is the judge not dealing with, and I'm talking about initially, not the judge that's sitting today, because there are judges sitting today, but why did the judge originally not give adequate reason in his conclusion, in his ruling, for why the court deemed the behaviour antisocial? That still today hasn't been given, and this court don't seem to be looking for it, and that's a problem. Why are the Court of Appeal not seeking the reasoning of the judge in first giving the order? Why are they not dealing with the unlawful nature of how the order first came about, and rather discussing the proportionality of the order as the first port of call? When, if they can tell why, if they can say that that how the judge came about the order is unlawful, none of proportionality will matter thereafter. It won't matter. The proportionality or the nature of the order or any of that wouldn't matter if it can be seen that how the judge came about the order was unlawful. And what I mean by that is, guards have no jurisdiction in civil matters. It has been ruled by the High Court that they cannot play prosecutor. So, knowing this, that a guard can never prosecute, this case must be quashed. It must be thrown out. But they cannot abandon the testing of the constitutionality of the sections because it has been brought before the High Court. And they submitted that it should be done. So all this is preemptive of what should have been done first. They're doing this cart before the horse. And that's how they're trying to avoid dealing with the most pressing issues and bypassing them and sidestepping them and dancing around the point. Because the devil's in the detail, man. That's where he is. That's where he resides. That's his field. And if he can get you looking at the detail and not the core issue, he has you distracted. And that would be the first thing he'd try to do. Distract, decoy, put it in place. And it seems to be the order of the day. Let's look at the proportionality, let's look at the detail, let's look at whether Mr. Tallon should have been prevented from speaking in the environs of Wexford. Oh, come on, that's too much. Isn't it? All right, well, maybe it was a bit harsh. No, the main reason that needs to be addressed today is whether or not the way in which I was first brought into court was lawful, and then how the judge came about his ruling. What are his reasons for even thinking that Mr. Tallon was behaving in an antisocial manner? That has to be the directive of this court today, and if it's not, they've failed. Talking about the detail, talking about the proportionality of the order itself, whether that's reasonable or not, or whether it's equality, or whether it's submitting to equality and human rights, they're not irrelevant points, they're not mute points if you are addressing with something that had been proven to be reasonably come about. They seem to be at this stage assuming that the judge's ruling in the first place was justified, when they're here to judicially review his decision, not just look at the proportionality of. That's really after the fact. If you can say that the judge came about his ruling unlawfully, the proportionality of the order no longer matters in terms of whether the convictions stand or not. It mightn't be a mute point to an academic or to somebody who's involved in law, so I won't dismiss that, but it's a mute point when it comes to whether or not the convictions stand or not. Because disobeying an order is disobeying an order. But the warning on the order is this. The warning on the order is this. You must comply with said civil order unless you have a reasonable excuse not to. Well, I ask you, can you, as a man of the land, as a man of Ireland, be prevented from speaking in jail? No. Well, then why should you be expected to stop speaking outside of jail? That's a very simple question that this gathering doesn't seem to want to address yet. Now, the day is young, but why would they be starting with the proportionality of the order and not whether the order should have come into existence in the first place or not? I'm seeing dancing. I'm seeing an irregular sequence here. It's irregular. We're focusing on detail now and ignoring whether the ruling was justifiably given in the first place or not. So, I just want to make you aware of a number of issues here. It has been ruled in the High Court that a guard cannot prosecute. He's not entitled to give evidence on behalf of another guard. That means that this case must be thrown out. With respect to the convictions. So, this judicial review is rather after the fact. It's rather by the way, because, and that's not to undermine what's happening here today, they might not fully be aware of that. It has been stated in High Court that a guard cannot prosecute in court. He cannot do it. He cannot give evidence on behalf of another guard. He's not allowed to do it. He's not allowed. So what was he doing in the civil court, trying to give evidence against me? What was he trying to prosecute me for, if he's not supposed to be prosecuting? And why aren't the courts saying, no, guards aren't allowed to prosecute, throw this out? Throw these convictions out. We're not revisiting these convictions. But it's a good exercise for this court to decide as to whether somebody should be told they can't speak or not. That's ridiculous. The proportionality of the order. Can any man here be told to stop talking? Can any man here be told to stop talking? In Ireland? Any man here, can you be told to stop talking? The answer will always be no. Why? Freedom of expression, freedom of speech. Now the next point is, yes, but what you're saying matters. You can't talk about obscenities. Okay, so that's what we need to focus on. We need to focus on what was being said. Okay, because you're not allowed to be obscene in your speech, or the guard can arrest you. But then there would be a criminal offence. So what are we seeing? Criminal offences are naturally antisocial behaviour. But antisocial behaviour cannot be separate to a criminal offence. In other words, you can't call something antisocial that is lawfully permitted. You can't call something antisocial that is lawfully permitted. And if you can't arrest a man for doing something, you can't call it antisocial. So we have to establish then, the court has to establish, was what I was saying unlawful or not, in order to ratify as to whether the court's ruling in saying I was antisocial or was justified. So they're remiss in searching that. Really, you know, the proportionality of the order is one point, but it's misleading. It leads away from the core issue. It's dancing around the point. It's not an entirely mute point, and so that's why one might submit that it should be discussed, but it's not the most important point, and it becomes irrelevant to whether there should be a conviction in place or not if they show that the judge didn't give sufficient or adequate reason for calling me antisocial. And if the judge didn't have reason for calling me antisocial, he was remiss in doing so. And he actually defamed me. A judge defames you if he calls you unlawful when you're not. And if he was calling me unlawful, if the court was saying I was antisocial, they must have been saying I broke the law, and then they were remiss in not arresting me. Because if a court is saying you broke the law so you're antisocial, they should have arrested you, not let you go free. Or at least arrested you with a warning, saying if you break the law again, you go to jail. But they never said I broke the law. The judge didn't say I broke the law. They said we found that you have behaved in an antisocial manner. Well, I'm here to tell you guys, you can't behave in a socially acceptable manner and break the law. And you can't be engaging in a lawful activity and be antisocial at the same time. So there's a disconnect that the courts here haven't addressed yet. So I'm glad of the hour break so that we can discuss these issues. Why is this court not addressing the mens rea of the judge in terms of how he came about the ruling? Why? Why is that not the first order of the day? First on the list, first on the schedule. Did this judge come about this ruling according to the law? Did he give adequate reason for his ruling? Why has it not been said as the reason for the judge calling me antisocial? Saying this court finds that Mr. Tallon behaved in an antisocial manner. How so? Be specific. How are we supposed to learn if we're not specific? How am I supposed to be expected not to do the same thing again if they're not going to tell me which part of my behaviour was incorrect? How? How am I supposed to know what I did wrong if they don't tell me why they're telling me I did wrong? What kind of behaviour is that of a court? It's the court's responsibility to inform the public when they find that they've behaved unlawfully as to why they behaved unlawfully. They should be telling them, this is why we find you behaved unlawfully. And if they're not doing that, they're withholding, and that's not good. The court shouldn't be withholding. They should have no reason to withhold, unless they're trying to conceal misconduct, their own misconduct. The court of this land has to give reason for their ruling. Why are the higher courts, the investigatory courts, when they seek certiorari here, why are they not asking, did the judge come about his ruling according to the law? And why was he reluctant to? Why did he refuse to give reason for his ruling? And why are this court not asking what that reason was? Why has no court so far asked, why did the judge call Mr. Tallon antisocial? Because that would be directly dealing with the issue at hand. That's why. And these are dancing. And they have to stop dancing. In Yeshua's name. The courts here have to do their job. They have to establish, why was Mr. Tallon called antisocial? And what are the implications of being antisocial? Can anybody here around in the courts be told not to record? No. Why? It's a freedom in Ireland. You've no expectation of privacy in a public place. So if you're out in public, you can be recorded, and that's lawful. There are CCTV cameras all over the place. Can a guard tell you to put down your phone and stop recording when he's recording you? Where's the equality in that? People standing around here are allowed to record what's happening in public. It becomes suspicious behaviour when somebody tells you to stop recording when it's otherwise your right, and they don't give adequate reason according to the law as to why they've asked you to stop recording. Can anybody here be told to stop talking? No. Can they be told to stop recording? No. Can I tell that man to put down his phone and stop talking and stop drinking that coffee? No. He's a free man. He's not in jail. Can I tell a man in jail to stop talking if I'm an officer of the jail? Well, you can tell him, but you can't force him. And so why should it be normal for somebody who's not in jail to be told to stop talking by a court? Imagine an order that says, no speaking in public or recording. No speaking and recording was the wording, and was the word. No speaking and recording in public. Well, why not? No, we're not going to talk about why. No. We won't talk about the why. Hypocrites. They always want to know the why. But when somebody else asks the why, they don't want to tell you. So this court has to address the issue of the day, and that's judicial review. Judicial review is establishing whether the judge came to his ruling in accordance with the law or not. The judge must come to his ruling in accordance with the law. When a judicial review is being carried out, they're trying to establish whether the judge has come to his ruling in accordance with the law. That he didn't step outside of that remit, outside of his powers, that his ruling was not come about in a way that was an ultra vires of the sections under which he was attempting to rule on that day. Can anybody here be told not to speak? Can anybody here be told not to speak in public? Can anybody here be told not to speak in public? Can anybody here be told not to record in public? Can anybody here be told not to speak in public? Can anybody here be told not to record in public? The answer to both those questions is no. Can a prison officer stop you from talking? The answer is no. So how can a guard stop a free citizen from talking? The answer is they can't. So if a guard can't, then why can a judge think he can? He can't. So the proportionality in terms of the geographical extent of the ban, the area covered by the ban, is rather a moot point in establishing whether the ruling of the day was come about lawfully or not. Whether the judge was justified in placing a ban that placed an apprehension on a citizen who was told they were free to go, that they should not speak or record in a public place. I call that bullying and misuse of power. Nobody here can be told not to speak. Nobody. Nobody here can be told not to record with their phone. Nobody. Not by a judge, not by a prison officer if you're in jail. Can you be told not to speak? So why are this court failing to address the core issue of the day, which is, did the judge come about the ruling in Stephen Talon versus the DPP? Did the judge come about the ruling that I behaved in an antisocial manner in accordance with the law? Because if a guard is telling you, you're not breaking the law, Mr. Talon, but you must stop talking, there's a disconnect. Can a guard tell you to stop speaking? No, of course not. Maybe if you're in court, yes. That's a different thing. But out in the street, in a public place, the guard cannot tell you to stop speaking. Ask them. They might request that you stop speaking while they're investigating something. But can they tell you that if you don't stop speaking, you're going to prison? No, they can't. They cannot. So that's the issue of the day. The issue of the day is not whether or not the proportionality, the geographical location, the area within which we told you couldn't speak, whether you use the speaker or not, all the details, we'll dance around the point, No, the issue of the day is, did the judge have an entitlement to tell a man he shouldn't be talking? And the answer will be every time in every law book, no. Only if he's in court at the time can he be told to be quiet or be escorted out of the courtroom. But he cannot be told not to speak in a public place, period. And this court has to submit to that today. They have to. They have to establish whether or not the judge came about his ruling in accordance with the law. And how can a person be expected, if a guard is telling them they're acting lawfully, to then submit to be remaining silent at the same time? You're acting perfectly lawfully, but stop talking, won't you? No, absolutely not, would be the answer. There is no authority extended to a judge that allows him to tell you to stop talking. There is no authority extended to a judge that tells him or allows him he can remove your right to record in public. Because there's no expectation of privacy in public and you have a freedom of expression. The only time a judge can arrest you for speaking is if what you're saying is obscene or inciting violence. The only time that your speech can break the law is if you're inciting violence or you're speaking obscenities. You see the point? Obscenities are unlawful, free speech is not. So, no, just speak it. Doing a live video.
Yeah, what's it about?
Well, you can listen.
What's it?
You can listen. It's about Stephen Talon versus the DPP. It's about your freedom of speech.
Oh, yeah.
So I ask you a question. Yeah. Can I ask you a question?
Yeah.
Can a guard tell you to stop talking?
No.
So why can he tell me?
What can he tell you?
Can a judge tell you to stop talking?
They say it, but they can't make it.
So in court he can tell you to stop talking.
Yeah, in court
But can
they did, but I wouldn't.
Right. Can he tell you to stop talking out here?
No. Freedom of speech when you're on the streets of Dublin, streets of Ireland.
Can he tell you to stop recording?
No, you can record, take photographs, do what you like.
So why are they telling me I have to stop talking?
As long as you're not putting him on social media. Do you know what I mean?
Well,
and that way then you will get fined.
Yeah, apparently you're not allowed.
Taken down like that.
Well, you're not allowed to record what's going on in the court.
In the court, yeah.
The video.
Yeah,
because it's already recorded.
You can, but look at. You can, but if you hold the phone, look at, in your hand, in it sideways, and just leave it, and let the judge hear all the cases.
Well, the point of the matter is,
they can't do one.
Yeah, that's right. You're entitled to.
Just as long as you.
Yeah.
Just have your phone on there.
What's your first name?
Glenn.
Glenn. I'm Stephen.
Stephen, yeah. Nice to meet you.
Glenn, blessings. All the best blessings. So the point is this, right?
Yeah.
That if you're in a court of law.
Yeah. I spoke
there's a certain
and the sergeant said to me 3 times.
Can I just say, Glenn? Can I just say something?
I'll fine you if you don't go out of court.
Can I say something, Glenn, to you, just in response?
Yeah.
That the judge has to submit to you the digital audio recording of the day.
Because I want to look at.
So he's recording.
The toilet rolls, I took the whole lot of them out of the toilet.
I wouldn't be doing that.
I did.
Or broadcasting. So the point is this.
Don't blank that bit out, yeah.
So the point is this, right? Point is this. Glenn, listen.
Will you blank that bit out though?
Listen.
Yeah.
What's happening in court has already been recorded.
Blank that out though.
It's already been recorded.
Yeah, but can you not? You can put a thing over it.
Just forget about that.
Yeah, I don't want to. No, because I don't want to get in broadcast and hearing that I robbed toilet rolls out of the toilet.
All I'm going to say to you, Glenn, is your face is not on this video.
Well, that's okay. I'm glad.
But all the point I'm making to you is this: that everything in the courtroom is already being recorded.
Yeah. Yeah.
It's called digital audio recording.
Yeah, that's right. Yeah. So look at you have a reporter sitting there.
I know.
You know, and the guys out here, just see the guys with the cameras.
Yeah.
Well, see when they're in there.
Yeah.
What they're recording, right? Straight away, then when they get enough recording, they send it straight to the guy outside with the camera, and then he picks up the camera, and he knows what guy. She'll tell him it's a fella in a blue jacket coming out. He's after being up on a paedophile charge, paedophile caught on his computers or something. Do you get me? Yeah. So they pick up the cameras and the you might as well say the friend that's in there that be recording like that, right? Have a dictaphone at the side, right? But she has her mobile too, so she has it done twice. So there's a dictaphone on the counter. I've seen it loads of times on the button on. You know what I mean, Mrs. Kelly and Gary Shane. They put their phones and they hold their phones in their hands sideways. They're recording everything that the judge says, even in different cases that's not even involved with them. Do you know what I mean?
Yeah. So you have an entitlement to record what's being said in court.
Yeah.
It's just that they tell you not to do it because they're
I know
doing
they tell you not to, but like I said, see there you have it there. You do that. Look at. Put it down sideways, yeah? It's still gonna record you. Do you get me? Once you hold it in your hand and your phone doesn't ring in court, if your phone rings in the court, you'll have to start doing that. Whose phone is that? Whose phone is that? You know, and you know, if it keeps ringing, he'll walk out to you, he'll go to the sound where it is. So once your phone doesn't ring in the court, you can hold your phone. No, you can actually hold your phone up that way. You know, lean your hands on
Glenn, I'm just going to get back to making this. I'm going to get back to making this video, Glenn. And have a nice day, yeah?
Yeah, you
All
too.
the best.
All the best. Stephen, is it?
All the best, Glenn.
Right. Green patchy face on.
So, the point I was making was this, and Glenn agreed, you have the freedom of speech in Ireland. No guard can tell you to stop talking. No guard can tell you to stop recording. No judge can tell you to stop talking. No judge can tell you to stop recording. No civil order can be put in place to stop you going about your freedoms, period. So these guys talking about proportionality of an order that is unlawful is really a disgrace to these courts. It's a disgrace to these courts. Judges, high-paid judges, who are members of the bar, operating in this court of appeal at this level, talking about the proportionality of an order that never should have lawfully been given, is a disgrace to this court. That's contempt of court. If these guys fail to address the reasoning of the judge, that's a disgrace to the court. If they fail to address the most pressing issue of the day, was this man breaking the law or not? Because a civil order cannot be put in place to prevent you doing something lawful. So how did this man break the law is the question of the day. Talking about the ins and outs and the detail of the order is a moot point when you haven't established whether or not the order should have been given in the first place. If the order shouldn't have been given in the first place, talking about the details of the order is after the fact. And the fact's been ignored. Deal with whether or not the ruling is lawful or not. What's an antisocial behaviour? An unlawful behaviour. This is very important, guys, that you're not deceived in this. A crime is an antisocial behaviour. A lawful activity is not. So how did the man break the law that you're now telling him he can't do something? And anyway, guys, listen very carefully. If that man's not in jail, you can't tell him to stop talking. That exposes that the reasoning of the judge was incorrect and he didn't operate in accordance with the law. Why? Because you can never remove the freedom of speech of a person. Not even in jail. Are you getting the point now? They want to dance around the proportionality of the order and the equality of the issue. Did the judge act lawfully in his coming to his conclusion and the issuing of his ruling? A civil order can never be preventing somebody from recording. Listen again. A civil order can never be stopping a person from recording in public. Listen again. A civil order can never be stopping a person from talking in public. Well, if that person was talking obscenities, they should be in jail because they've broken the law. And if they talk obscenities again, you put them in jail again. You don't stop them from talking. It's very simple. If you break the law, you go to jail. Or you get a warning, depending on whether the judge is lenient or not. You don't get stopped talking. Listen now. Because these courts are out of order. They're out of order. They're not complying with the laws of the land here. They're not complying with the laws of the land. They're not submitting to the rights of the citizen. And therefore they're failing in their office to uphold the rights of the citizen, which is the primary function of the court. The primary function of the court is to uphold the rights of the citizen. They're failing. They're failing. I hope that they do their job today. A guard cannot prosecute in a court. That's how these convictions came about. A guard can't prosecute. Well, if a guard can't prosecute, what's he doing prosecute? And what's this court even entertaining convictions on the basis of a guard prosecuting? The High Court have ruled that guards can't prosecute. The High Court have ruled that guards can't represent the evidence of another guard. Well, what do you think an adult behaviour warning is? When it gets to court, the superintendent is representing the evidence that his underlings have brought to him. He's not lawfully allowed to do that. So here we have a court, so-called, and we'll respect it, so long as it respects the authority it's given. This court has to do what is right by the law and the citizen. And this court is here to uphold the right of the citizen. That's the primary function of a guard. Listen again. Law enforcement. What is the function of the law? to preserve peace, to conserve the rights of the citizen, which are to reflect peaceful living. Now listen, somebody losing peace because somebody else is allowed to engage in their rights and freedoms is an evil reaction, and we shouldn't entertain it. We should not entertain somebody trying to harm another person because they don't agree with their opinion. Listen again, we shouldn't entertain one person trying to harm another because they disagree with them. And you telling me I can't speak in public is you harming me, because you're harming my rights. Do you understand? With no lawful reason. So what's the question of the day? Is it ever unlawful to speak in public? The answer is, it's not whether you're in public or not, or whether you're speaking or not. It's what you're speaking that matters. What are you speaking? Is it obscene? If not, then you haven't done anything unlawful. If your speech is obscene, then a guard is remiss in not arresting you. Squeaky brakes. If a guard sees that you're speaking obscenities and he doesn't stop you, he's not doing his job. If a guard tries to stop you speaking, even though you're not speaking obscenities, he's not doing his job, but is breaking the law. Can a guard stop anybody speaking out here? No, the guard will tell you no. Can a guard stop you recording out here? The answer is no. Here I am, outside at the criminal courts of justice, speaking and recording, and inside they're discussing whether stopping somebody speaking and recording in the entirety of Wexford was proportional or not. Proportionate. They're speaking about the proportionality of an order that never should have existed. That's what they're going to employ these court buildings for? To say whether removing my rights in all of Wexford was reasonable or not. Removing my rights, period, is unlawful. Right? I'm surrounded by guards doing their job, and none of them have an issue with me speaking here today. But as soon as I started shouting obscenities, they would be over to arrest me, and that would be proper. If I speak obscenities, the guards are within their rights to stop me speaking, to protect the young ears of the children and other things of that nature. How you doing? Does anybody here have the right to speak? Yes. And our guards are here to ensure that that can continue, because they're law enforcement. What does that mean? They have authority to ensure that the law is being observed and upheld. But as soon as they use their power or their physicality to remove the rights of a person, then they come under the law. That's misuse of power, misuse of office. Somebody strong coming against somebody weak, trying to hinder their freedoms, is unlawful in Ireland. Now listen, the only time your freedoms can be reduced is if you break the law. Listen again. And if you break the law, you should be in jail. Unless you come up against a lenient judge. But his leniency should be limited. His leniency should also be reasonable. Do you understand? So listen, guys. It is never lawful for a judge to remove your right to speak. Never. Because he can't even do that if you're in jail. Let's make that very clear. It's very simple, guys. A judge can never stop you speaking. Never. Any law that says he can ought to be removed because it's unconstitutional. It's not really a law, therefore, it's only a writing. Can somebody come here today, call the guards and take my phone off me for recording? No. Can they stop me speaking? No. Well, how does the judge of the district court think he can? Again, guys, we have to look at the specifics. The only time speaking is unlawful is if it's inciting violence or is obscene. Therefore, if a guard didn't arrive at arresting you for obscenities, if I speak obscenities, then a guard can arrest me. If I incite violence, then a guard can arrest me. But if I don't, then they can't stop me from speaking. And they'll tell you that themselves. They wouldn't pass their exams in Templemore if they said otherwise. So why are judges behaving worse than our guards? Trying to stop us from speaking. And why are the courts here failing to address the most pressing issue of the day? Is why would a judge ever attempt to remove the freedom of speech of a man? Why would he ever do that when his primary function is to ensure that the rights of the Irish person are upheld? His primary function is to reinstate your freedom as soon as is practicably possible. That's why in America they're called correctional facilities and not prisons. Because the idea is that the person is rehabilitated to becoming a functional citizen again. Functioning citizen. How can you be a functioning citizen if you're not allowed to speak? How can you be a functioning citizen if you're not allowed to do what the other citizens are allowed to do? Why? Would you tell a man he can't talk? You would tell a man he can't speak obscenities. You would tell a man he can't incite violence. But you can't tell a man he can't talk. Do you see the distinction here, guys? So we have to discriminate. We have to differentiate between the lawful conduct, lawful ruling of a judge and the unlawful ruling or the unlawful conduct of a judge. So I'm going to head back in now soon. So guys, I respect these courts, I respect these judges. They're learned men. But what they're not doing is they're not so far, and they should be from the outset. The most pressing issue of the day is, why would the judge ever tell a man he can't talk? You can tell a man don't speak obscenities, you can tell a man don't incite violence, but you cannot tell a man don't speak. You can tell a man don't speak obscenities, you can tell a man don't incite violence with your words, but you cannot tell a man don't speak. That's not lawful. That is tyrant behaviour. That is an occupancy of our country, of our state, by those who would keep you silent. That's tyrannical occupancy of our country. That's trying to conquer a country by the pen. These judges have to submit to the law like we have to submit to the law as citizens. It's not unlawful for me to stand here and disagree with the judge in there, but I do have to love, honour and respect him. And what's most important is we have to uphold the law here together today. The citizen and the judge working together to ensure that we go forward on the proper footing. That's what these judicial reviews are about. Because judges are just human beings, they make mistakes. And they're often led to make mistakes by improper legislature. No guard can tell you to stop speaking, they wouldn't try to. But they can tell you to stop speaking obscenities. They can tell you to stop inciting violence with your words, but they can't tell you to stop speaking. As a general rule or order of the court. It's ridiculous. Ridiculous. The only one who can tell me to stop talking is my mother at the dinner table, or a judge in his court while I'm in there, or those who serve him in there, the guards. But so long as you're a free Irish man walking around the street You have the freedom of speech. Now, I don't want to go over and ask a guard and catch him on the spot when he's on his lunch. But these guards know that they have no jurisdiction in civil matters. They don't have jurisdiction in civil matters. So why would a guard ever be telling a man he can't talk? They do. Why would he ever be trying to go into the civil court and prosecute somebody when the High Court has ruled that a guard must never prosecute? The High Court has ruled that a guard can't represent the evidence of another guard, of his colleague. So come on, guards, do your job. Come on, judges, do your job. Submit to the law of Ireland. Uphold the rights of the citizen, and this court should address the main and most pressing issue of the day, which is, why would a judge ever ask a man to stop talking? And the judge is remiss in not telling the man why he should stop talking about certain topics, if those topics are considered unlawful to speak about. That's a big if. The only thing that is unlawful to speak about are obscenities and the inciting of violence. You're not allowed to incite violence with your words. Say, let's go and kill those people. A guard could arrest you if you said that and meant it. And he might even inquire as to why you were saying that. You might say, excuse me, why are you saying that? And then you say, well, I'm just giving an example. Okay, well, be careful. And the guard could come over to you and try to get to the bottom of what you're doing there. He might try to de-escalate a situation. But the guard can never tell you stop talking. Where are we? In Ireland? Stop talking? Can the judge tell you to stop talking in Ireland? It's ridiculous. The judge can't tell you to stop talking. That's preposterous. That's absolutely preposterous. And these men, these learned men, these well-educated men, are not asking the question, why did the judge ever tell this man to stop talking in the first place? They're talking about the proportionality of the order. The order is unlawful in its nature. You can't tell a man to stop talking. So they're not asking why it was an unlawful order given by a civil court on the basis of a prosecuting guard, when a guard's not allowed to prosecute and has no jurisdiction in civil matters. Why aren't these the issues being addressed today? Blessings.